Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. Let's break down a case that changed how courts think about this area of law. Imagine closing a business deal without ever signing a contract, only to find out later that you're legally bound anyway. That's exactly what happened in Brogden v. Metropolitan Railway Co., a classic 1877 case that still traps businesses today. In this Law Conquer video, I'll break down how this coal supply lawsuit changed contract law forever, while your handshake or email could be a binding contract, and the simple steps to protect your business from accidental agreements. Whether you're a freelancer, business owner, or manager, understanding acceptance by conduct will save you from expensive legal surprises. Watch now to get the practical breakdown. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. Alright, let's start with the real-world problem. Every business owner has been there. You're negotiating terms, you've got a draft, but the ink isn't dry. Yet, work begins. This chapter reveals why that's a legal minefield and what Brogden teaches us about the danger of assuming you're not bound. In business, a contract doesn't only form when both parties sign a document. If you act as though an agreement exists, delivering goods, paying invoices, or starting work, a court may help with your conduct as acceptance. This often surprises entrepreneurs who think nothing is final until it's signed. The truth is, your behavior can bind you to terms you never formally agreed to. In Brogden v. Metropolitan Railway Co., years of coal delivery without a signed contract backfired when a dispute erupted. The lesson: understand that actions can create binding obligations even if the paperwork is missing. Legal cases from the 1870s might seem remote, but Brogden's dilemma is timeless. Small businesses, freelancers, and startups often operate on handshake terms or email exchanges. Without clarity on when and how a deal becomes binding, you risk expensive misunderstandings. Imagine delivering a month's worth of services only to have the client say there was no contract. Brogden won its case, but it took a court battle to prove it. Avoid that fight by knowing the rules of acceptance by conduct. Many people think a draft agreement is just a proposal, nothing more than a discussion tool. But if that draft contains detailed terms and you start performing, you might be accepting its entire content. This is a trap for the unwary. A supplier who begins shipping goods under a draft pricing schedule could be stuck with those prices even if later they want to renegotiate. Always mark drafts as subject to contracts and refuse performance until the final sign-off. A little clarity up front saves a lot of legal heartache. Let's review the key takeaways. If this helped, like the video and subscribe for more case summaries that make law study easier. Remember, this is a summary for study purposes. Always read the full case. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.